Representative Larvadain, on your bill.
Thank you, Mr. Chair, and thank you, members, for being here. I know it's been a long day, but thank you for your professionalism. This is HB 379, provides for liability for damages caused by sexual harassment. As you all are aware, sexual harassment has no place in schools, universities, or workplace. We want our students to be safe. We want employees to be safe. This bill is straightforward. This allows someone who has experienced sexual harassment to seek punitive damages. As you all are aware, punitive damages are punishment. We are punishing the perpetrator, not the business. Business are not required to purchase additional insurance. We're trying to hold that person accountable for the bad conduct. What we're trying to do is that we're trying to deal with punitive damage. We're trying to stop bad behavior, and we want to encourage bad conduct, and we want to make sure that we change the culture of how we deal with sexual harassment. If you don't punish bad behavior, it will continue. With me next is Ms. Morgan Lamondre. At this time, she's going to make a statement. Thank you.
Yes, Morgan Lamondre with Star. We are here in support of this bill, and because of the time constraints, I'm happy to just entertain any questions. I think there is an amendment to the bill.
There is one, yes. At this time, can I get someone to offer that amendment? That's just the description.
Yes, we don't have a quorum. Hang on just a second. Let's see
I'm
if we
sorry.
Yeah.
I can offer. Yeah, I like to offer it. It's actually.
Okay, but we need a quorum. Hold on just
Okay.
a second, if you would.
Okay.
Rep Larvadain.
Thank you.
Tell me when we have enough.
Do you want to explain the amendment? Or
Yeah,
you
I've
you-
got the amendment.
okay.
All we do is just add anything else.
We added a definition of sexual harassment.
All right. We've got an amendment.
Yes.
All right. Ms. Pirtle, talk about the amendment.
Members, this is Amendment Set 2028, and it's online. You're going to insert the amendment defines acts or acts of sexual harassment in the workplace as provided in RS 4234-2.
Yeah. Mr. Chair, all we wanted to do was clarify the definition according to the statute, so that's a part of the amendment, so everybody would understand it.
So is it actually a definition, or we're just referring back to where it is referenced?
Chairman Morgan Lamondre again. The definition we're talking about, it refers back to a definition, but because the definition that the statute is referring to includes parts of other items, it's referring to the public servant sexual harassment bill. It's the way the amendment is the acts described in that particular statute it's referring to. So it is somewhat referring back to the definition, but not in its entirety.
Okay. Do we have any questions on the amendment? Any objections to the adoption of the amendment? Seeing none, that amendment, set number 2028, is adopted.
Thank you.
All right. On the bill as it now stands. So.
Which I can just
Go ahead.
say, we're happy to entertain any questions, but like Representative Larvadain said, this is not a punishment for businesses. In fact, most of the time, your typical Title VII type of claim is usually against a business, but a business could very much do everything that they're supposed to do. They could respond efficiently and effectively, and this is really about the perpetrator. And because not all survivors of sexual trauma have cost in the same sense, this allows for there to be a deterrent for punishment of the perpetrator. And I think most of us know as Americans, there's nothing, what makes this country great is to be able to go to work, have a job, and work hard. And when you have somebody who interferes with your ability to safely go to work, this bill really is about those bad actors and putting punishment on the bad actors, while also allowing for there to be, recourse for a survivor who, like I said, the business could have responded efficiently and effectively to address the behavior.
Okay. And again, the bill is providing for exemplary damages, that punitive damages
Punishment.
in other places. But that only applies to the actual perpetrator.
Perpetrator.
So if someone is sexually harassed and suffers damages and is legitimately and seriously affected by that, they would, right now they have a cause. They possibly may have a cause of action against their employer.
Right.
But-
That doesn't.
but-
This
but
doesn't
Not in
change
this
that.
one, no.
But this exemplary damages would not apply to the employer.
Right. And I think, the point that can be made, I know there's been previous discussions about insurance. The truth is, it's going to be hard for people to necessarily bring claims, at least for an attorney to take on a case, especially when there isn't third party liability, unless that perpetrator is pretty solvent. With that being said, this still allows for a survivor who maybe goes to an attorney to have that as an option. And so there is that deterrent effect if they are able to pursue. The likeliness of, having an attorney who would take on a case like that, we know is probably not as high, but it still allows the option.
All right. Thank you, Representative Freeman.
Representative Larvadain, what is the current prescriptive period for this type of action?
Are you?
I think it should be 1 year.
Okay.
No, 1
Well-
year for 1 year for your regular tort claim.
Right.
Now, I'm not. What is if they're
So there are certain sexual harassment acts that, if it does fall under the sexual assault definition, would be subject to a 3-year prescriptive period. So this really does fall in line what is the current law. There are certain acts that may not involve a touching that do not. That currently would be around the 1-year mark. But once again, those are really actions. Those remain for employers. This does not change the prescriptive period for sexual harassment against employers.
So are we changing the prescriptive period to 3 years for all of these types of acts now?
No. So right now, if you go to, I think, if you
Well, I
give me
guess
one
my
second.
question is, if we're not changing the prescriptive period, why are we putting in the statute?
It would change for specific behavior that constitutes sexual harassment that does not involve a touching, which are certain limitations to those. So, of course, an attorney, you'll love this answer, right? It depends. So right now, sexual harassment could fall under conduct as far as against a perpetrator. It could typically fall under a 2-year prescriptive period that we have that allows for civil claims against damages that involve sort of a criminal, that have a corresponding type of criminal statute. We also have the 3-year prescriptive period, but I'm trying to think of a type of sexual harassment conduct that wouldn't fall under what is currently 2 years or 3 years. So this doesn't change the employer-based one, which is 1 year. Hopefully I'm answering your question. I know it's kind of confusing, but it really does depend on, I'd have to know more facts about what conduct we're regulating. But right now, typically of the types of conduct that fall under the sexual harassment statute, it's usually a civil period of, and this is against the individual who committed the offense, not the employer. So against the individual of the offense, right now, it's 2 years or 3 years. So we're really, for the conduct that doesn't fall under the sexual assault statute, it would be increasing it to 1 year, increasing it by 1 year.
So we are increasing the prescriptive period for some actions from 1 year to 3, or even 2 years to 3.
It's possible. It's possible. It would be very limited if so. Like I said, if you give me a fact scenario, I could.
Well, let me just ask you this. I mean, we've just heard oodles of testimony why we need to extend a prescriptive period for these other things. Why do we need to extend a prescriptive period for these actions? What is the compelling interest of extending prescription?
Well, I think for workplace trauma and all, there could be various, for any survivor of sexual trauma, right? Like a 1 year prescriptive period. Usually there is a touching that's involved. There may be a criminal statute violation, but once again, it's sort of the same research and background where survivors need to heal and a chance to sort of, get therapy and really understand what's happening to them. A lot of times survivors try to suppress emotions they experience from the sexual trauma, and they're not able to get out of their house or go to work. And so I think for survivors, this allows them to sort of have an additional amount of time. But once again, to be honest, I don't think this is really going to affect most of the acts that would constitute sexual harassment. I think would fall under that already 3-year prescriptive period.
Thank you for answering my questions.
Representative Seabaugh.
Thank you. Mr. Chairman, members, I know we've been here a long time, and I really don't want to belabor the point, but I have a question about the amendment. Explain to me the reference to 42-342 and why we're putting that in the statute.
Well, there was some discussion about the need to actually reference a statute for sexual harassment, and because I think we just wanted to make it clear about what could constitute acts of sexual harassment. The law that it references it just had a definition. It was dealing with the statute involving like the public servant bill that you all passed like a couple of years ago, but I guess by not having a definition, it could be subject to interpretation. So I personally wouldn't have cared if it didn't have it in there, because I think there's law that clearly defines acts of sexual harassment, but it was an attempt to sort of anticipate a question from you.
Okay. Thank you. No, it kind of jumped out at me because it seemed somewhat misplaced, but if y'all had a reason for putting it there, that's fine. It doesn't affect how I'm going to vote on the bill. I was just curious.
We just want to make sure that everybody understood what we're trying to do. So a lot of times when you pass a bill, when you have a bill, we also want to reference to a statute that deals with the definition so everybody would know we're on the same page. So that was only for clarity.
Okay. Thank you. That's all.
Thank you, Representative Seabaugh. All right, the board is clear, and we do have some cards not wishing to speak, present, and in support. Peter Robbins Brown, Louisiana Progress Action, not wishing to speak, present, in support. Adam Eitman, Office of the Governor, not wishing to speak, present, in support. Zach Lemoyne, Governor's Office, not wishing to speak, present, in opposition. Bobby Taylor, and not wishing to speak, present, and in opposition. Ryan, cannot make out the name, Crawfish Industry. So
Pretty sure it was 331.
oh, that might have been for 331.
The crawfish.
I mean, somebody representing the crawfish industries may be opposed to this. Well, all right. All right. So, with that, the board is clear. Representative Larvadain, you can close on your bill, and I'm sure you're making a motion to report this with amendments.
I make a motion with amendments, but understand we're trying to change culture. We're trying to deal with bad actors. This will not affect the business community. Business will not be required to pay additional insurance. We're holding the perpetrator accountable, not the business. Asking for favorable passage, Mr. Chairman.
All right. Representative Larvadain has moved to report House Bill 379 with amendments. Is there any objection to reporting House Bill 379 with amendments? Seeing none, House Bill 379 is reported with amendments.
Thank you, Mr. Chair. Thank you,
Now-
members.